Jeff Tenenbaum is one of the nation's leading nonprofit attorneys and also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on a broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award and is one of only 5 lawyers in the prestigious U.S. Legal's 500 Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance, and currently serves as the chair of the American Bar Association's Trade and Professional Association Subcommittee. He is also on the ASAE Legal Advisory Council and Public Policy Committee. So I would love to introduce Jeff. Jeff, welcome. Thanks for joining our group of event professionals today. We are adapting to a new environment, so we're excited to hear some of your best advice on all of that. I also, before we get started here, want to encourage everyone. I have a couple of questions in pocket here, but what we really want to do is hear from all of you. So please make sure that you throw your questions in the chat, and I promise we will make our way around to all of you with anything you want to ask. So with that, Jeff, welcome. Let's dig into some event questions. Is there anything you want to say before we get started?
Thank you for the kind introduction. Nice to meet all of you by video, although I can only see your pictures, not your live faces for most of you. But feel free, please, like Jamie said, I encourage you to ask as many questions as you can, follow-up questions. And also, if you have any experiences or examples to help illustrate some of the things we'll be talking about, feel free to chime in with those as well. Just so you know, kind of my perspective on this and where kind of what I'm going to be talking about today comes from. As Jamie said, I've spent my whole 25-year legal career in private practice representing associations and chambers and other nonprofit organizations, but primarily membership associations more than anything else. The start of this year, my colleague and I formed Tenenbaum Law Group as a boutique law firm focused exclusively on the representation of associations and nonprofits. We represent about 275 organizations right now. And not surprisingly, have spent the better part of this year, since March already, helping hundreds of associations deal with their upcoming meetings and conferences. For most of 2020, the primary goal was to cancel in-person meetings and conferences, pivot to virtual ones, and try to mitigate and minimize or eliminate cancellation penalties under those contracts. That process continues. And my colleague Nisha and I spend part of every day counseling clients on these issues, and it continues. And we have association and other nonprofit clients that every day are still looking to cancel their in-person gatherings in the first and second quarters of next year. I will say that's become much harder to do. The hotel and convention center community has really dug its heels in much more than they were several months ago. The landscape is most definitely changing. And then we also advise on every other aspect of meetings, from the contracts for future meetings, whether it's a rebook of a 2020 meeting or pushing a 2021 meeting to later in the year, and what sort of contract provisions we want to try to be able to negotiate and insert into those contracts, to the holding of in-person meetings. There are many associations and chambers and other nonprofits that are contemplating in-person meetings for next year at different times. And as an attorney, I get the question all the time, well, how can we do that in a way that mitigates our risk? Different types of risk. Risk from an allegation that an attendee or even an employee contracted the virus at your event and decides to bring a claim against you for negligence, to contractual liability for holding an event, but if your contract has, for instance, attrition penalties, which are the penalties that you pay if you don't meet your guaranteed minimums for sleeping room revenue and or food and beverage revenue, then you can get hit with attrition penalties. So if you go ahead and you hold an in-person meeting under a contract that was negotiated a year ago that contemplated 300 attendees, but you only end up getting 100, you could get hit with some really significant attrition penalties. So what can you try to do in advance of that to work with a hotel to try to mitigate those penalties? These are a lot of the issues that we're dealing with. I get questions about liability waivers for attendees. I'm getting a lot of questions. This is not in the meeting space, but about office reopenings and what do we need to do to mitigate our legal risk there. So I am presuming if this goes like every other one of these that I've done, and I've done quite a few this year, probably going on close to about 80 of these types of virtual webinars. Those are going to be the nature of the questions. I sent to Susan to share with all of you links to a bunch of articles that I've written on these topics this year, covering all of these issues in more detail than we'll be able to get into on the webinar today. So Susan's going to share all those with you. And there's some good resources there, including a model liability waiver for conference attendees that you guys are free to use. So with that as background, Jamie, why don't you fire away and we'll take the next.
Yeah, absolutely. I'll start off with a question. We'll await some questions from the group here. Please don't be shy. I know you have them. I know you're kind of walking your way through a whole different environment here on these events and being able to host them. I'll start with liability waivers because I have several private attorneys in my board or extended relationships here in my chamber and in my community who I've asked, should I take that as a necessary step and precaution along with masking and hand sanitizer and social distancing and all the things being asked of me? What are the teeth in that? And is it kind of early in the process to really know how much that can protect your chamber? I appreciate you saying you also put a sample out there, but talk through those waivers a little more because I see a lot of chambers struggling in that space.
Yeah, first off, what we're talking about is a liability kind of release and waiver for attendees that attend an in-person conference. Okay, we're not really dealing with, there's really no purpose for a liability waiver for a virtual conference, but for in-person conferences, because of the risk of contracting COVID, it is actually starting to become the norm and a best practice for any entity, whether it's a venue, whether it's an association or a chamber, anyone holding an in-person event. Kind of started, the biggest name that started was Disney World, where they started requiring liability waivers to be agreed to and signed by any visitors to the Walt Disney World parks in Orlando, Florida. And it's I think it's going to become the new normal as in-person events start to occur again until the virus is very much in the rearview mirror, which is probably going to be some time. So the question is, should you require your attendees to sign some kind of a liability waiver? Short answer is yes, you absolutely should, in my judgment. Most people, just like you click and accept on a website that you agree to, you accept the use of cookies, for websites to track you. Almost everyone clicks and agrees with those pop-up, click and accept buttons that you don't even think twice about. No one even reads them. You just click and accept. And I think that's going to become the norm for these things. It is a known risk. Everyone knows it's a risk. I mean, you walk outside your door or you go into your local coffee shop or grocery store or wherever else, you know there's risk. You're kind of voluntarily assuming the risk. All the liability waiver is saying is, look, I am knowingly assuming some risk. And if I contract the virus here, I'm not going to hold the chamber liable. That's pretty much what it says. Is it the silver bullet end all be all that is going to protect your chamber from all liability? No, absolutely not, because liability waivers get tossed out by courts all of the time for a variety of reasons. So it's not bulletproof, but it is helpful. It's one tool in the toolbox of liability risk management. Jamie, you mentioned some of the others, right? You're not going to just have a liability waiver and then not have all the proper social distancing and enforcing mask wearing and reminding people not to show up if they're not feeling well, maybe doing temperature checks, having regular, making sure the venue, the hotel, the restaurant, whatever it is doing regular, high quality sanitation and all the other things that have become kind of the new normal. And most people are fairly, and I'm going to talk about those things, by the way. It's not a substitute for those things, but it is a helpful tool and I do recommend it. The last thing I'll say about liability waivers is I recommend, and it's the model one that I gave you guys in that article. I wrote for an association, the Georgia Society of Association Executives, that had one of the first in-person conferences since COVID. And I actually attended it in Savannah, Georgia in late August, probably about 150 people. And I thought they did a pretty terrific job at all of the protocols. Nobody got sick, as far as we know. I was a speaker there, and it was a very successful outing. But I wrote that liability waiver for them, and I wrote the first part, kind of what I described to you. But then I added a second part to it, which basically says, I, the attendee, agree to follow and honor all your protocols. Right? I agree to wear a mask in all public areas. I agree to social distance. I agree to not go out, to crowded bars at night and then come back and potentially infect people the next day. And you're laughing, Jamie, but this is real stuff. I mean, this is actually
It's true.
In a place like Savannah, Georgia, where sometimes you walk around that city and you would not know that there is a virus going around this country. There were packed, crowded bars. And if an attendee goes to a venue like that, even if they're wearing a mask, it's a much higher risk that they could get infected and then infect others back at the conference. So I wrote all of those things into the liability waivers, kind of an affirmative obligation on the attendee, in part so that the association, the sponsoring organization, could say, look, we did everything possible. We were not negligent in how we ran this meeting. So that's another tool in the argument of, look, we did what we needed to not be negligent. But it also kind of serves as an affirmative reminder to the attendees that, hey.
It's actually bringing to mind for me, Jeff, I've had a couple of experiences. You assume that the people you're interacting with understand taking those general protocols, but I've actually found myself in a 14-day quarantine because a member stopped in and told me 45 minutes in that they were sick. They'd taken a COVID test the night before, and I was the first person they'd met with in person. So to your point, it's not only about regulating, but then also about managing behavior of the multiple people that we come in contact with around these events. And there are some questions actually being thrown out here that build upon what you're talking about. It looks here like a couple of people asked, do you need an actual piece of paper with each signature on it? Or is there some kind of, by registering for this event, umbrella that covers that? And then somebody else asked also, whose responsibility it is to provide those precautionary measures, masks, hand sanitizer. I assume the person producing the event, but also wanted to ask you to follow up on that as part of that question as well.
Okay, so the first part of it, these days, whether you click and accept something online or whether you have a physical signature on a piece of paper, it has the same legal effect. You want to obviously be able to keep a record of it. But the key here is to make sure that it's clear and obvious to everyone that they're agreeing to. If you just had it, this is one reason why liability waivers sometimes get thrown out. If you just had it in a bunch of text in your, all your registration rules and conditions and everything else about refunds and all this other stuff, and you just had a paragraph thrown in there, it wasn't highlighted, it wasn't like a separate click and accept or something like that, there's a good chance the court might say, no, registrants did not knowingly agree to it because it would be hard for them to spot it. You didn't flag it out. So you want to have something where they are, it doesn't matter to me whether it's a physical signature or an electronic click and accept, even as part of the registration process, but have it be a separate acknowledgement, affirmative obligation by the attendee to agree to that. In terms of the question of whose obligation are these things, so this gets into kind of what are the other things that you need to do when you're holding an in-person meeting to help mitigate your liability risk. So I'm going to use that question as a kind of an entree to the broader discussion of when and how can a chamber be held liable if someone alleges they contracted the virus at your event and says that you were negligent. Now, the issue of causation is always going to be a difficult one, right? If one person says they contracted the virus at your event, but there's not a whole cluster of people that contracted it at the event, it's going to be difficult, if not impossible, at least with our current testing protocols, to know and prove that someone contracted it at your event. If you get, 10 people, 15 people, 20 people that all contracted at the same time, it's going to be much easier to prove causation in that situation. But causation aside, the basic standard here for negligence liability is, did your chamber satisfy the appropriate standard of care that existed at the time for holding that meeting? This is kind of basic negligence liability that lawyers like me always learn in your first year of law school. And the question is, so what is that standard of care? Well, first off, the standard of care, I'm looking around the screen and all these boxes of people all across the country. The standard of care is going to be different in each one of your cities and states, because one of the places that informs what the standard of care is are laws and regulations in your state and city. And as we all know very well, they vary wildly across the country, not only from state to state, but from city to city. You look at a state like Texas, and the rules in Dallas versus Houston versus Austin versus San Antonio are all very different, and the Texas governor allows for that to happen, whereas in other states it's very different, and the governor does not allow for a lot of variation in these rules. But there are a lot of mandates in states and cities across the country that say, if you are going to hold in-person meetings, these are the things you have to do. And I think we're going to see even more of those as larger meetings are allowed under these various state and local laws. Right now, a lot of state and local laws still ban larger gatherings. A lot of them permit them. My colleague and I do this analysis every day in different places. It keeps changing. Some places like Florida are just insistent on essentially having no restrictions in most places. Whereas in other places like where I am at in DC, there's still very strict gatherings. You can't basically have a conference of more than 10 people or 25, I forget what it is. But you got to follow the state and local mandates. That's part one of the standard of care. Then you look, secondly, to recommendations, advisories, things like that. So at the federal level, at least right now under this administration, there are no federal mandates when it comes to these things, but there is a lot of advisory guidance, particularly from the CDC. And in my most recent article, the one that you'll see about like the top 10 things to keep in mind for association meetings, something along that. One of them talks about and links to 2 sets of CDC guidance for large gatherings. And there's some very detailed guidance, not mandatory, but certainly part of the standard of care for negligence liability, because it is from the federal government, it is from the CDC, and it's very detailed. And so to answer the person's question, some of those obligations fall on the meeting organizer, like the chamber. Some fall on the hotel or the venue, and some are a combination. It's not clear, where they fall. I mean, you can interpret it as you read it. And some are going to be, the obligation, for instance, to enforce mask wearing or to enforce social distancing, that's not going to come from hotel staff if you're having an event at a hotel. It's got to come from your association staff and volunteer or your chamber staff and volunteer leaders. But things like all the sanitation requirements are generally going to fall in the venue and things like that. So another thing you want to do when you are trying to make sure you're living up to that standard of care is you want to contractually obligate the venue to do everything that they need to do. Whether it's in the contract itself, ideally, or at least in an email exchange, you want to get them to agree to all of the things they are going to do. You go through that list of CDC recommendations and pull out the ones that you think are relevant and doable and cost effective enough to make work, and get them to obligate, to agree to the fact that they will do these things. What we're finding is most hotels and event venues, convention centers are telling everyone, yep, we're open for business. We're going to do everything we're supposed to do. But when push comes to shove, they really don't want to do anything more than the bare minimum because it all costs money and they have no money. They're hemorrhaging money. So it's become a bit of a struggle. You really want to get them to agree to do those things, both to protect the health and safety of your attendees, but also to help mitigate your liability risk, because it's another example of how you are showing you are not negligent. And then finally, beyond things like the CDC guidance or other state and local guidance that's not mandatory, but is advisory in nature, there are increasingly other kind of best practices that are evolving. For what some people are calling safe meetings, like in the state of Michigan, the government worked with chambers and associations and CVBs to come up with this really detailed kind of guidance for safe meetings, which I think is great guidance that it doesn't matter what state you're in, you could follow. So look to those sorts of things to get ideas. Basically, the more you do, the less likelihood that you're going to be held liable for negligence. But you got to balance these things, right? Because you guys are struggling financially as well, and you're not going to be able to engage in things where you have to hire a bunch of extra, security people or other things where you probably don't have the money to do that. But there's a lot of low-hanging fruit. There's a lot of easy things you can do to help mitigate the liability risk.
Yeah, to kind of shift off waivers, we've had lots of questions in there. I think we answered some of it around a God clause or precautions or being able to have a questionnaire and ask the questions. I think kind of your takeaway in that, similar to alcohol policy as an example, if you have an event, someone leaves that event, you have it at someone else's facility, but you're the organization hosting, there is a tie between all the partners, and at the end, the liability and the process lies with you. So that's really good advice. Someone asked, do you anticipate legislation will get passed that helps with the liability for businesses? And can you talk more about that? I can say in our state, I was with a mask week 1 of COVID over at our legislature listening in about what was happening around a presumption of guilt for businesses before they maybe proved themselves innocent or had a chance to take those precautions. So do you see that environment just getting more tenuous, or do you see that improving as we work our way through this?
First off, if I had the crystal ball on liability protections for employers, I'd probably be in a different profession. As you may know, the issue of liability protection for employers primarily, you say businesses, but we're primarily talking from an employment perspective. The issue of if an employee contracts the virus, can the business be held liable? There is a ton of litigation out there making those sorts of claims. A lot of it going through the workers' compensation process, some of it maintaining that it should be able to proceed outside the workers' comp process. Right now, that is one of the conditions that the Republicans in the U.S. Senate have maintained for any new COVID relief bill, that it has to contain those liability protections. On the Democrat side, the House Speaker, Nancy Pelosi, has pretty much taken a hard line against that. Whether there is even going to be some sort of a federal COVID relief bill in this, what they call lame duck session of Congress in December, it's definitely too soon to tell. My personal prediction is the odds, I think, are better than not that there will be some sort of bill, and that both sides are going to obviously make concessions in order to come to the table. And especially, I read some stuff yesterday that suggested that the Senate Majority Leader is definitely softening his position. I would not be surprised if there's some liability protections for employers built in. Perhaps not to the same extent that the Senate Republicans have been pushing for, but I wouldn't be surprised to see that. I don't, though, expect that to really affect liability for holding meetings. I think it's going to be more on the employment side. Does that answer your question?
Yeah, I was going to ask too about insurance. That comes up in some of your articles, and it also comes up for some of the folks here. So, I think your answer was good on the last question about these are mitigation strategies only. We don't really know what the course of litigation will be around all this. It's still playing out. But I would be curious from a protections or mitigation. We've talked a lot about masking and social distancing and things. If you are producing an event you might want to do, what are some of the insurance strategies or just other ways that organizations can host those live events inside guidelines, but also accommodate for insurance and other protections, if you can weigh in on that?
Sure, I'm glad to. First, let me just close the loop on employer liability. One of the articles that I gave you guys is all about how to reopen your offices and mitigate your liability risk. The analysis is not dissimilar from what we just talked about with respect to meetings. There's a lot of similarities. It's the same kind of issue of negligence and what's the standard of care. You also, obviously, you've got to look to state and local mandates, and there are a lot of requirements, like here in neighboring Virginia where I'm at. There are specific requirements about office. If you're going to go into an office, these are the things you have to do. So that's where you first look to see what the standard of care is for office reopenings. But then you look, just like on the meetings analysis, there is federal guidance, not mandates, but guidance from what's called the Occupational Safety and Health Administration, OSHA. You've probably heard about before. It's the principal kind of federal agency that regulates workplaces. They have 2 sets of very detailed guidance on things you should do for safe office reopenings. And they include all the stuff we talked about before, but then they also include things like plexiglass partitions between cubicles and having people come in on a staggered basis. And so everyone's not there at the same time, and banning people congregating in common areas and all sorts of things like that, along with all the other things that we talked about. So, you want to do all those things to help mitigate liability risk. One thing on the waiver front, I've gotten that question a lot. My article addresses this. Generally speaking, it is illegal in most states for an employee to sign a liability waiver that waives their rights under workers' compensation. Right? They're not illegal, but it's null and void. Like it doesn't have any legal effect. So pretty much waivers in the workplace setting are going to be useless because most claims, if an employee claims they contracted COVID at the workplace, are going to have to go through the workers' comp system. So a waiver is not going to do you any good there. But you do want to do all of those things. Regarding insurance, sorry, just making a note on one thing. I'm actually doing a program next week for ASAE, a speaking panel on insurance issues in connection with COVID. And we just had a planning call about this yesterday with myself and a couple insurance brokers. And we were talking through these issues. So in terms of insurance, what we are seeing, and not surprisingly, insurance companies, just like so many other parts of the economy, are taking a huge hit because of some huge claims that they have endured. Coupled with the fact that the insurance market generally, I learned more about this yesterday, had even pre-COVID really been tightening things up in terms of forcing reduced amounts of coverage and forcing increased premiums. Basically, the losses have been getting too great, and so this is like a correction in the insurance market. You couple that with COVID, and what we're seeing is a lot of changes in the insurance market for all types of insurance. Sometimes more than others. So let me talk, you can't just say insurance, you got to break it down by the different types. So for COVID related claims, there's probably three that I want to talk about. One is called commercial general liability insurance. One is called workers' compensation insurance, and one is called event cancellation insurance. The analysis is different for each one of these. They all serve different purposes. There's other types of insurance, like nonprofit directors and officers liability insurance and other things. Although that insurance it never covers claims for what are called bodily injury or property damage. So things, claims about someone contracting the virus are not going to be covered there. So let's talk about each one. So I'll start with event cancellation insurance. In the past, there were about 4 leading event cancellation insurance carriers. Carriers are the ones that underwrite the insurance. Each of those carriers generally excluded coverage for what they called communicable diseases, which would include COVID, but in all of them, you had an opportunity to pay a higher premium, usually about 20% higher, and get coverage for communicable diseases. Many organizations did, many did not. Many more did not than did, unfortunately. We have a number of clients that did have coverage, and we've been helping them work through the adjudication of their claims with the insurance carriers, and they're actually going to get a lot of money for lost profits and out-of-pocket expenses in connection with canceled meetings from 2020. A lot did not. And if you still have, like some organizations would purchase multi-year event cancellation policies. So if you were lucky enough to purchase a multi-year policy a year or so ago, and you still have a policy that was bound, meaning issued pre-COVID, and it covers some still upcoming future meetings, and if it does not exclude communicable diseases, that's a lot of ifs, but if that's the case, you're going to be in really likely in pretty good shape. Not definitively, though, that discussion is beyond the scope of this webinar. If you're in that situation, I'm happy to talk to you about it, because there is a lot of nuance as to when and how you submit the insurance claim. But for most of you who are not going to be in that boat and do not have event cancellation insurance already, the bad news is that A, premiums have about doubled from where they were pre-COVID, and B, you can't even purchase communicable disease coverage. It's completely excluded by all the policies, and that is likely going to stay that way for some time, probably quite a while, unless there's a bill pending in Congress to essentially create like a federal backstop for things like event cancellation insurance and business interruption insurance, similar to what happened after 9/11 with terrorism insurance, where all the major carriers were excluding terrorist acts, from covered claims and a whole bunch of different types of policies, property policies and everything else. Federal government stepped in, passed a bill to create this federal backstop and kind of a federal guarantee fund. And it really made a huge difference. And now, like for event cancellation insurance, you can purchase terrorism coverage for a slightly increased premium. In fact, you can generally do it in different levels. But that was the result of the federal bill. Hopefully that federal bill in this area will be passed to provide that sort of backstop and help that market. On commercial general liability insurance, so that's the insurance that a lot of people refer to as slip and fall insurance. It does cover bodily injury and property damage. And one of the places it does apply is at your conferences and meetings. So it does provide coverage for that sort of thing. In the past, there's about, I was told yesterday, there's about 36 insurance carriers that offer commercial general liability insurance to smaller organizations like your chambers and whatnot. And in the past, about 50% of them had exclusions for communicable diseases, and about 50% did not have exclusions. So there's no express coverage for communicable diseases, but generally, if there was no exclusion, then it should be a covered claim. And it would still deal with issues about causation, like I talked about, but should be a covered claim. Going forward, though, what we are seeing, not surprisingly, is that all the carriers, and when these policies come up for renewal, they're now excluding any claims for the virus, which is not surprising. Insurance like this, liability insurance, is designed to cover against unforeseeable claims, and COVID is no longer unforeseeable, unfortunately. And so, again, at least for now, it's going to be virtually impossible to get coverage that if someone alleges they contracted the virus at your meeting and they file suit. Under prior policies, you should have coverage if you're in that 50% that did not exclude it, but going forward, that's going to be difficult. And finally, workers' comp. I need to, this is what I was making a note about. I need to do a little more research on what percentage of the policies had some sort of virus exclusion in the past and which did not. My basic understanding is that most did not. And what I also don't know is how workers' compensation insurance policies are changing now post-COVID or during COVID. I'm suspecting they are all going to do the same thing and add exclusions for COVID-related claims in the workplace. But that's where we're at on insurance.
I have kind of a two-part question for you. This advice today is invaluable, and I think for all of us on the call, what would you suggest for us? There have gone from maybe being a weekly question for legal advice around what we're all managing to there maybe being several times a day legal advice needed. And I'll give you a specific circumstance. Maybe give us advisement on how chambers can best tap into that resource around being able to ask these questions. And, I know there are legal collectives, there are individual attorneys who specialize. We'd love, since you live in this space, for you to share with us how a chamber can best attach themselves to that resource. But to give it a specific example too, I'm curious, if an organization like ourselves has a situation where they go to a bar or restaurant and they have an event there, and someone actually tells them that one of the bartenders or someone involved at the business has to be shut down because one of their employees contracted COVID, and you had an event there. What is the chamber's liability in expressing and communicating that to members? For example, many people on this call are probably working with investors who want them to get out there and have live events. They want them to get involved again. The businesses are, in an emotional space about needing to help their business survive. But the chambers on the call also are trying to manage all of the guidelines and stay inside them. They may have a member who encourages them to have a live event, and then there's a contact tracing. What is their liability in the information they give up? Should they be deferring to that business to actually give that information? Should they be giving that? There's just a lot of circumstances happening right now. So I'd be curious, where do they seek advice, and what is their liability in that? What are they required to disclose or give to the person calling in to check on that?
Let me take the latter one first. So it's going to be the same basic analysis we talked about for in-person meetings generally, right? First, what is the standard of care? What are you obligated to do? Okay. I believe that some states, and especially cities and counties, do have some requirements about affirmative notification of people if you know that a group that you are organizing and whatnot, that someone in a group had contracted the virus. That some, especially, I don't know if any states do it, but certainly in I think some cities and counties affirmatively require you to notify everyone. And frankly, it's going to have to be you notifying, not the venue. Like, for instance, though, like in DC, restaurants can be open with 50% indoor capacity, but whether you're sitting inside or outside, you have to give a phone number and a name one of the people in the party if you're making a reservation, because the restaurants are obligated to notify everyone under contact tracing protocols in DC if they later learn that someone at the restaurant that day had the virus. So again, you look first to what's mandated, and then second, you just look to what is the basic standard of care? What's the best practice? What do you need to do to not be negligent? I think there's no question that if you become aware that someone at that restaurant, a worker, one of your attendees, one of your employees, whatever the case may be, had the virus at that time, that you absolutely have an obligation to notify people. And I think you could absolutely be held potentially liable for negligence by not notifying them. Because then they could later spread it to a bunch of other people. They might not know to get tested sooner. They could, who knows? And things are changing in terms of treatments for the virus. And if you get treated earlier, it can help, stave off worse health conditions. All those things factor into why you absolutely, I think there's no question yet that you should be notifying your folks. In terms of, how to get legal advice on this, look, this is tough. I work with about, 275 organizations right now. Some really large ones that can afford to pick up the phone and, call us every day and ask us to review this or draft that. A lot of medium size and a lot of small groups that can't, don't have the resources, especially in this environment, to do this. I thought this is great on behalf of, Susan and ACCE to organize this. And I've done this sort of thing. In fact, I'm doing another one later today. I've done this for a lot of different groups like this, where the individual members probably a lot of them don't have the resources to be able to go out and pay for specialized legal advice on this stuff. But getting legal education from forums like this, and I'm happy to, do this again in a couple months or whatever, can be helpful. Also, that's why I shared those articles with you. To the extent that I write more, which I'm sure we will, share those with you. Those can be very helpful. There certainly are a lot of other kind of free webinars out there that you can tap into to take advantage of this. But, I will, and I'm not saying this out of self-interest, there are going to be times where you need legal advice, and legal advice means it's specific to your situation. One of the things that I've seen after doing this now for 9 months is that every one of these situations, whether it's a meeting contract cancellation or liability protection, getting the general advice is very helpful, but there's some real strategy and tactics involved in pulling this off successfully, especially when it comes to the meeting cancellations and rebooks and postponements and whatnot. And, like you could listen to, 15 of my webinars on this stuff, but, I can really only deliver that really necessary added value by counseling you specifically in your specific situation. And whether it's me or any other attorney, that's what I'm saying. That sometimes there is no substitute, for some actual legal advice, but it doesn't have to be expensive. I've had a number of small groups come and say, we really need your advice to counsel us through, in this meeting cancellation and help draft a termination notice for us and tell us when to send it and review what we're sending out to our members and whatnot. And we can often do all that for $1,500 or something like that. And I'm not saying that might be a lot to your organization, I'm not sure, but I'm just saying it doesn't have to break the bank to get legal advice either. You just need to balance all those considerations and do what you can to protect your chamber.
Yeah, that's helpful. On a high level, I think you have a hard stop here in about 4 minutes, 3 minutes, maybe. Do you have time for one last question?
Yeah, I have 5 minutes. I have a board.
5 minutes. Okay, good. If you were to kind of summarize top level, how chambers mitigate risk in this environment, and I know we've got a lot of directions here, what are the top 3 takeaways today for everyone on this call they can do to protect themselves in this environment and ensure that their members are safe and their staff? What are your top recommendations, things that should be top of mind?
I think the number one thing is you don't have to reinvent the wheel here. Everyone is going through the same thing as in-person meetings become more common, and they already are becoming more common in certain parts of the country, not in others. But as they become more common, as offices start to reopen, which is happening in some parts of the country, not in others, common practices, best practices have already started to evolve and will continue to evolve. Look around. Don't be a trailblazer. Just look at what others are doing. Ask your colleagues. You guys are a great forum here, of sharing information and ideas. I've been following closely, the few larger associations that have had in-person meetings. I've seen some really good kind of, let's digest and break down what happened and what worked well and what didn't. What are the challenges? Like The biggest challenge I saw at the meeting I was at in Savannah in late August, they did a great job on everything they could, but the one challenge, and there's no easy solution for this, is when people are at receptions, particularly kind of stand-up receptions, where you're drinking and maybe you're eating some appetizers. It's really difficult to do the mask wearing and the social distancing in that environment. And it's even worse when it's indoors, when you can't always have it outdoors. That's a real challenge that I think meeting organizers need to come up with a solution. Kind of the entire rest of the meeting, from the meeting education rooms to the lunch tables where you get big round tables and everyone's spaced out so you can take your mask off and eat and feel more comfortable, eat and drink. But at the stand-up receptions, that's a challenge. But I have some ideas for how to deal with that, but others are going to come up. The smart meeting planners are going to come up with ideas for how to do this stuff. So look around, ask around, see what others are doing, participate in some of these listservs and forums and other things, and get ideas from others. You don't have to reinvent the wheel.
Yeah, no, that's great advice. We really thank you for all the great advice you've given today and all the resources. Again, I think just don't rely on yourself. Do ask your colleagues, ask for help from ACCE. They have a great resource catalog there, and there are just a lot of places to go. Also, don't try to assume anything when it comes to this litigious environment. Make sure you seek a professional who can give you some advice when you need to, and when you find yourself in a tough situation. So with that, I just want to thank Jeff so much for all of the great information today. We appreciate you. Thank you very much.
Yes.
My pleasure. All right, guys, enjoy the rest of the conference and your weekend.